On this morning's docket. That's case number 108021, State of Kansas v. Killings.
May it please the Court, Your Honor, Christina Curls of the Appellate Defender Office for Mr. Killings. Request 3 minutes for rebuttal.
3 minutes is granted.
I'd like to focus my argument on the first issue of the brief and submit the others on the brief unless this Court has questions. And the first issue involves the District Court's denial of requested lesser-included instructions for intentional and reckless second-degree murder. And the first, glaring issue with the District Court's denial of these lesser-includeds is the fact that it applied the wrong standard in denying them. And when the District Court denied the intentional and reckless lesser-included instructions that were requested, it did so because it stated that the jury could find premeditation, where we know that the actual standard in determining whether or not a lesser-included instruction is appropriate is when you view the evidence in the light most favorable to the defendant, if there is any evidence which could reasonably justify a conviction of the lesser. So it seems, first of all, that the District Court looked at the evidence in the light most favorable to the prosecution and found, well, the jury could find premeditation, so I'm not going to give the lessers. And moving on to the actual, merits that the lesser included requested were appropriate in this case. The state doesn't contest that they were legally appropriate because intentional second degree and reckless second degree are obviously lesser degrees of first degree premeditated murder. So the state does not contest that. Where the state and Mr. Killings differ is whether or not the evidence supported them. First of all, with the intentional second degree murder, as we pointed out in our brief, the only difference between first degree with premeditation and intentional second degree is that premeditation element.
You would agree that there's evidence, I don't necessarily need to characterize it, but there's evidence of premeditation.
Yeah, which is why we didn't raise a sufficiency claim on the first degree. When you view the evidence in the light most favorable to the state, absolutely. The jury could have found premeditation, and they did find premeditation. We aren't arguing that the evidence was insufficient to find premeditation, but rather that there was evidence presented which could have reasonably supported a conviction of intentional second degree murder. And that evidence was testimony provided by three different state's witnesses. The first of all was Bobby McCrae. And Miss McCrae was the one who spent the most time with Mr. Killings. She's the one who testified that she went to Mr. Killings' house to trade some marijuana for some crack cocaine. She saw a gun on Mr. Killings' floor, but never saw him pick it up. I mean, it seems clear that he had a gun if the state's to be believed that he had the gun on him. But still, Miss McCrae didn't testify to anything that Mr. Killings did in his house that would have indicated that once he knew that Mr. Jackson was at her apartment, he intended to go over there and kill him. The state tried to argue that, Miss McCrae told Mr. Killings that Ghost, Mr. Jackson's nickname, was at the apartment, and at that point Mr. Killings asked if he could go over there. Well, the state left out a couple of details. If you read Miss McCrae's testimony in context and in order, it appears that she went over, she made the trade. Mr. Killings asked, well, who's all there? Miss McCrae didn't just say, well, Ghost is there. She said Ghost and 4 or 5 other people. It wasn't just Mr. Jackson's name that was mentioned. Mr. Killings then asked, well, what are y'all doing? Miss McCrae said, we're partying. At that point, Mr. Killings asked to go. The jury could have interpreted that evidence to find, well, Mr. Killings just wanted to go over there to party. He wanted to go over there and smoke some marijuana and smoke some crack cocaine and drink with this group of people. That is a possible interpretation of that evidence. Simply because it could be interpreted to support premeditation does not exclude the fact that there's another interpretation as well when you view it in the light most favorable to the defendant. And that's what the state attempted to do, is twist it so it's only viewed in the light most favorable to the prosecution and not the defendant, which under this standard, under this review, we have to view it in the light most favorable to the defendant. The second witness would be Arlene Love. Arlene Love testified that when Mr. Killings entered, he fired shots. Ghost evidently recognized his face and went to lunge at him. Now, our argument is that the jury could have interpreted this, particularly when taken with the testimony of Renee Stewart that we'll talk about in just a moment, that it's possible Mr. Killings went in there, or when he fired his shots, he went in there to scare Ghost. He went in there to scare Mr. Jackson because there was evidence presented that Mr. Jackson, along with someone else, had previously robbed and beat Mr. Killings. That he went in there to scare him, and then only once Mr. Jackson lunged at him did he fire the shots that killed him.
Is it the testimony that the lunge was either simultaneous with the shots or even after he was shot? Isn't that the most credible testimony? Well, really the only testimony?
I reread it this morning, and while the state claimed in their brief that what Ms. Love testified was that after Mr. Jackson was shot, he lunged, the testimony is actually that after shots were fired, Mr. Jackson lunged at Mr. Killings. And while the distinction may seem small, when you're viewing the evidence in the light most favorable to the defense, there is an interpretation there that could be that Mr. Killings wanted to scare the man who had that he believed had previously robbed and beat him, and it was only after he perceived that he was being attacked that he fired the intentional shots to kill without the premeditation. So there is an interpretation of that evidence when viewed in the light most favorable to Mr. Killings that could support.
What was the forensic evidence about? It was 4 shots, right? That was the testimony.
I don't remember exactly. I know he was shot at. I'm remembering 3. If the record says 4, then.
And what was the forensic testimony about where all of those landed?
I honestly do not remember the specific forensic testimony. I know that there were witnesses that testified that they were shot in Mr. Jackson's direction.
So you don't remember any testimony that one went in the ceiling and one went over there, and
no, I don't.
It's not like he went in doing this.
No, there were witnesses that admittedly did testify that all of the shots were fired in Mr. Jackson's direction.
Thank you.
So viewed in the light most favorable to the state, then absolutely that could support premeditation. But viewed in the light most favorable to the defense, when you look at all of the testimony in context and the full picture, there is a different interpretation that's available. Now, particularly the jury could have taken Arlene Love's testimony with Ms. McCrae's and Ms. Stewart's to find that, as I said, the defendant wanted to scare him. Didn't intend on killing him, but wanted to scare him. But then when he was lunged at, that's when he, I guess, made the decision to shoot, which could support a finding of an intentional shooting, but without that premeditation. The main area that we argued that Ms. Stewart's testimony was relevant was for the reckless second-degree murder. Ms. Stewart testified at least twice during the trial that she didn't think that Mr. Killings...
How is her speculative belief relevant to reckless? I mean, it's just I think that he didn't mean to do it, or I think this. Why is that evidence that he didn't intend to shoot him?
Well, I guess...
In light of all the other evidence, you have one witness says, I don't think he meant to do it.
I guess my best argument for that is kind of turning around one of the state's arguments. The state, for premeditation, argued that it had to be premeditation. Mr. Killings couldn't have been defending himself because Ms. Love testified that Mr. Jackson lunged either to avoid being shot or to get the gun away from him. So the state is arguing that Ms. Love's speculation as to Mr. Jackson's reasons for lunging is relevant to the issue of premeditation. So therefore it stands to reason that another witness's beliefs about a person's actions that she witnessed would be relevant to the issue of intent, to whether or not those actions were intentional as opposed to reckless. And the state cited State v. Clark to argue that this one witness's testimony by itself wouldn't be sufficient. Well, State v. Clark was very different. And it was the defendant himself testifying, I didn't intend to kill the victim. The court found that that self-serving statement by the defendant himself wasn't sufficient to support the lesser included. Well, in this case, it wasn't a self-serving statement by the defendant. It was a state's witness. It was a witness called by the state who testified at least twice that...
And it is kind of confusing about what she's saying, isn't it? I mean, it's partly it could be interpreted that, yeah, I don't think he meant to kill him, but also it could be interpreted he wouldn't be in this situation but for the robbery. That is also kind of based on however you want to interpret it. That's the problem with speculative kind of I think this or I think that, and I don't know that that's evidence.
I absolutely agree that it's subject to interpretation, which I guess is my problem with why the lesser included wasn't given, because it's the jury's job to interpret that evidence. It's the jury's job to look at all of the evidence that was presented, Miss Love's evidence that was presented, her observations, and determine whether or not that opinion as to Mr. Killing's intent was supported by the evidence. Instead, the state interpreted that evidence and the district court interpreted that evidence to favor the state and decided not to give the instruction because the jury could find premeditation. And I cited it in my brief. I don't have the case cite off the top of my head, but the Kansas appellate courts have held that it's the jury's job to interpret the evidence.
In both, if we do find error on the second-degree intentional and the reckless, why isn't it harmless?
We would argue that it's not harmless, not only because of the, I guess, discrepancies in the witnesses' testimonies. First of all 5 witnesses who identified Mr. Killings as the shooter didn't initially identify Mr. Killings as the shooter the first time they talked to the police. Their stories changed. The state argues that what I'm asking you to do is we reweigh the credibility of the witnesses, and I guess that's part of it, but with the harmless error analysis, what you do is you look at the strengths of the state's case. And a necessary component of looking at the strength of the state's case is looking at the evidence that they presented. And if their evidence is witnesses who were smoking crack cocaine and smoking marijuana and drinking, with the exception of Miss Metcalf, and who all gave different stories to the police than they subsequently gave, that does affect the strength of the state's case.
Well, they initially gave a different story, and then, actually, for a case like this, the stories are pretty consistent. And then even I think the theory of trial was this was some sort of conspiracy because it was so consistent.
That was the defense.
But the stories and what they testified to was pretty consistent.
They were consistent.
And even what they told police after they initially had their first contact.
They were consistent with each other. They weren't consistent with themselves, if that makes sense. They weren't consistent
just from
with
the
initial
the very first encounter with some of them, they were reluctant to identify Mr. Killings. Is that right?
Right. And just very quickly, because I see that I'm on zero, the other reason that we contend that this is harmless is because the jury questioned it, or the question to the judge by the juror foreman. The juror foreman specifically asked the judge, we only have 3 options: guilty, not guilty, and hung. This indicates that at least one person on that jury panel, or at least it could indicate that one person on that jury panel wanted to know if they had another option other than premeditated first-degree murder. Whether or not they had to find that this guy, who 5 different witnesses...
How do you speculate that from that question? You think that's what that... just by wanting the foreman wanting to know the possible verdicts, you're speculating that leads to the conclusion that they were considering something else, and this was shortly after the deliberations occurred or began.
But it's not entirely clear when the question was asked. It was brought up after Renee Stewart's was read back to the jury by the district court, and that's gone into in more detail in the 3rd issue of my brief. But yeah, I would argue that that question does indicate that at least one witness was wondering whether or not they had another option. Or at the very least, the state can't prove that there is no reasonable possibility that one juror wasn't wanting to have a different option, that they wanted to know whether or not it was all or nothing, whether or not we have to find that this defendant, who 5 witnesses testified shot and killed this guy, is guilty of everything or not guilty of anything. We would argue that it is evidence that the error in this case was not harmless and that his conviction should be reversed and should be remanded for a new trial with both of those lessers given. Unless there are other questions, I would submit the remaining issues on the brief.
Any more questions? Thank you, counsel.
May it please the court, the state appears by Assistant District Attorney Jody Litvin. I'll go ahead and do the same, just focus on issue 1 unless there's other questions from the court. And I'll go ahead and submit the rest of the issues on the brief.
I have a question on the jury question.
Yes.
I wasn't altogether clear from the judge's comments at the motion for new trial. Can we? There was other indications that she had nodded
Yes.
in response to the question. Is that in dispute, that she nodded in response to the foreman's question?
Well, I think that the defense here is using that nod as to provide an answer, as though that nod was an answer in the affirmative, yes, that those are your options. And I think what my position on was that, and I thought about this last night, nodding versus shaking her head. She didn't say she shook her head no. She said she nodded, which would lead to a yes. But I guess my point in pointing that out was she said she nodded, but that's not indicative of an oral answer to the question. So I wouldn't say that she affirmatively said, yes, those are your 3 options by nodding.
You're suggesting it was just active listening, acknowledging there was speaking happening in her vicinity?
Yes, and that her answer was truly, if you have a question, this is your procedure in how to submit it to the court. If you feel that this question needs to be answered by the court, submit it in writing, and we'll go from there, and I'll tell the parties about your question. So going back to issue 1, the state's position here is that the only instruction that was supported by the facts was the instruction for premeditated first-degree murder.
Would you agree that the trial court, or what's your position, the test applied, it appears that the test that was applied on lesser included was, by the court, was the jury could find that this was, that this jury could find that this was an intentional premeditated act, and that was what she applied in her lesser included analysis.
I would say that despite the court's language that you could apply, or you could find premeditation in this case, that her conclusion was that was the only crime that was supported by the evidence. There was little argument on those lesser includeds, and the state responded in saying, well, I think we cleared up the 2 pieces of testimony that they used to request this instruction. And the court, I think really her determination, besides the fact that she used the word could, was that that was the only crime that was supported by the evidence. So she didn't really go into an analysis, but I think this court can find that that was her determination.
And how do we do that? How do we find that the court meant something different than what they said?
Well,
what
and that
she said.
in that she agreed with the prosecutor's testimony that evidence truly did not support those requests. Because I believe she made a comment, I agree with the state, in that we cleared it up, or something to that effect of Renee Stewart's testimony at least, and agreeing with the court, with the state's position that those pieces of testimony.
But if you have conflicting testimony and it's cleared up, isn't that just for the jury to weigh?
Well, I would say yes, but here I don't think that there's conflicting testimony enough that it provides some evidence that the jury could reasonably conclude that this was intentional or reckless. So going to the facts here, I did want to point out that they talked about Miss Love's observation that the victim lunged toward the defendant after he had made the shots, and I think that that's different from Miss Stewart's belief going to the reckless, in that Miss Love's observation is what she directly saw. She's not speculating on why he lunged. She's saying he made the shots, or at least there's an inference that the gun was already out and then the defendant lunged. So I think that's a direct observation that can go against intentional and not premeditated, in that he was shot, or at least the gun was out, and then he made the movements. There's no speculation on that.
There were 4 shots fired, and one hit the victim. One bullet went through the wall of the bedroom into an adjoining bathroom. Another bullet went through the bedroom dresser, ricocheted off a wall, and landed on the bed. And the 4th bullet went through another wall and struck the side of the kitchen oven. Why wouldn't that support that there may have been some warning shots rather than shooting at the victim?
I'd go back to the testimony of all of the witnesses that were in the room. And despite where the bullets ended up, his aim was directly at the victim. He didn't aim anywhere else in that room. I mean, there was a crowded room full of people. I'm assuming it was a small bedroom. I didn't go back and look at the photographs, but for 4 or 5 people being in that small bedroom, each one of those witnesses said he took aim directly at the defendant. So whether the bullets ended up hitting him or not, his intended target was clear. Also, one other piece of evidence that I think goes against the intentional as opposed to premeditated, when they were walking back, he had an opportunity to think about it then, which supports the premeditation, but when they entered into the apartment, I think it's significant to point out that there were 2 witnesses not in the bedroom area, and they said, "What's up, what are you doing here?" And he made some sort of gesture for them to be quiet, or indicated that he didn't want to be known. And with that evidence, I don't know how we can get to intentional and not premeditated when it's clear that he wanted to surprise the victim in the room. He wanted to go undetected through the apartment to shoot him.
I'm not sure I follow that. Can't you want to be undetected and surprise the witness if you're just trying to scare the witness?
Yes, but I think that goes away when you have the statement that he made once he's in the bedroom. So if there was no statement that he made before, or no gesture, and he had just walked in and shot the victim, I think that would go towards intentional and not premeditated. But the combination of him walking in, telling them to be quiet, "Shh, I'm not here," and then walking in, seeing the victim and said, "Hey, remember me? You robbed me," aiming directly and shooting, that combination takes away the possibility that he wanted to scare the defendant. And I don't believe there was any other testimony about Killings making any sort of statements that he was only going to come and beat up the victim or scare him, or any testimony about what his intent really was. And Ms. Stewart's speculation about she didn't believe that he meant to kill him doesn't rise to the standard of some evidence that would reasonably allow the jury to convict.
Well, let's look at it from a different standpoint.
Go ahead.
If we had a second-degree intentional conviction, and the ADO was arguing there was insufficient evidence, would you agree that in this case, there was insufficient evidence from which the jury could have convicted of second degree? Would we have to overturn that second-degree conviction?
It's hard for me to ever say that there should be insufficient evidence, but I don't know.
Well, if it's not reversible, why couldn't a jury reasonably convict? You understand where I'm coming from?
I do. I see your
Yeah.
point, and I hadn't flipped it around like
Yeah.
that, but I do understand your point. I don't know if there are any other. I think I've hit all the comments that I prepared. Going to harmlessness, if you want me to go to harmlessness.
I might ask you quickly, counsel, assuming that we were accepting the testimony from Ms. Stewart, basically, I don't think he meant to do it. Do you have any idea what she was expressing, what she was basing that opinion on, trying to get inside his head? The reason I ask that is because we were talking earlier to compare and contrast testimony from Ms. Love about he lunged, and then there was some indication, well, he did it for one of 2 purposes.
Right.
So do you have any idea what Ms. Stewart was basing her opinion on?
I think there was a lot of questioning about what why she made those statements. And again, Miss Love's was an observation, and she did speculate on why he lunged, but I think the sequence of pulling out the gun first and then he lunged is what was important there. But if I can remember back to what the prosecutor was asking, I think he was asking when she said that it was more of the situation didn't have to happen in the first place. This shooting was a result of the robbery, and I think she was trying to explain that the shooting would have never happened but for the robbery of the victim. And then I think there was a follow-up question that supports the premeditation here, and also the prosecutor, I believe, asked, so was this a revenge shooting for the robbery? And she said yes.
She said there was revenge.
So
So she wasn't helping us by providing evidence to indicate that there was sufficient evidence to support a reckless second-degree murder instruction. She was just expressing an opinion. Is that your view?
That's my view, yes.
Thank
And if she would have said, he told me he didn't want to do it, we had long discussion, there was no testimony from him indicating his intent.
Before you get over to harmlessness, let me ask another error question, and then you can go, you can go from there. On the prosecutorial misconduct, I'm bothered by the statement about his failure to accept responsibility. Because the quote is, "We are here because the defendant was given an opportunity. He failed to accept responsibility for his homicidal act." The part that bothers me now is, and now that responsibility is passed along to you. Your responsibility now is to hold him accountable for something of which he would not accept responsibility for. And when I read that comment, what that says to me is the prosecutors reminding the jury that the only reason why they had to take time out of their lives and sit through a bunch of lawyers arguing is because this guy did it and won't accept responsibility. And I'm having difficulty accepting that being within the wide latitude that a prosecutor ought to have. So how am I wrong?
Well, I think that it can be viewed in that way, but I think there was the fact that he didn't directly tell the jury or ask the jury, why are we here? This is a waste of time. And I think it goes back to a prosecutor can make a general reference to the acceptance of responsibility as long as they're talking about the evidence and what the evidence presented. And I think that's more of what the prosecutor was doing here.
That's what he starts out, but then you get to and now you're here. And that's the part that I think sets the hook.
And I guess I would just say that we have to take it as a whole, and we can't and isolate that statement maybe as much as
Then where else would I look to say, ooh, he meant something
Right.
else?
Well, I think we have to look at the closing argument as a whole, and I think that still, despite that one phrase there, I don't think he's intentionally making that blatant comment to the
Why
jury.
not? I mean,
Because the rest of the closing argument talks about the evidence, talks about the credibility of the witnesses, talks about the strength of the state's case. He doesn't go back to it and keep mentioning it, repeat it over and over. There was a recent case that I cited also that supported similar comments in that a prosecutor argued that the jury should hold the defendant accountable and that he was not accepting responsibility for what he did, and the court saw nothing more in the comment than a request for accountability, and I think that's similar here.
moving then to harmless, which is where you wanted to go. If we were to find on the prosecutorial misconduct that it exists with that statement, so we get now to a constitutional harmless error kind of analysis with that. And let's assume that we have some trouble with the instruction on second degree. On a cumulative error basis, do we have to look at this from the constitutional standard perspective in order to rule for you?
Well, I think on the prosecutorial misconduct issue, that's the constitutional error
It
standard
is, but
alone.
now I'm
And then-
saying we got, so if we're in constitutional land, do we have to look at the jury instruction error also from a constitutional perspective?
I don't know if that's clear, but if it would make sense to me that the higher burden would probably apply to both.
Okay, with that assumption,
Yeah.
make the case that this is a harmless error under the higher standard.
Okay, well, if I can kind of break it up into why it's harmless under each piece. In looking at the three kind of reversibility components for the prosecutorial misconduct issue, I don't think there's any evidence here that the misconduct was gross and flagrant in making that one comment. Again, it was not repeated. It came right at the beginning of closing argument. It wasn't emphasized again. And then the rest of the closing argument was very evidence-based and responding to defense counsel's statements about the conspiracy and about the weaknesses in the state's case. As far as ill will on the prosecutor's part, again, there's no evidence here of ill will. In fact, the defendant objected and the district court told him to move on and the prosecutor did so. So I don't think there's any evidence of ill will here. There's no evidence that he deliberately made this comment with the intent to persuade the jury that this was a waste of their time.
He continued the responsibility theme after the judge said, "Okay, move on." He said something about responsibility again right after that.
I think that's correct. I think he made
One
in
more
his next
at
sentence,
least.
and then he moved on. So I guess the point from my perspective would be he never went back to it, and it definitely wasn't repeated in some of the cases where we've seen ill will, where they are constantly going back despite multiple instructions from the district court not to go there. And this wasn't a longstanding rule of law that was disregarded here. So I think that it's clear that there's no ill will, and I think this court would have no problem determining that the record does not support ill will on the prosecutor's part. And then the overwhelming evidence, if you want me to go through it all, but I think as shown in issue 1 and in some of the other issues, there's absolutely overwhelming evidence to the defendant's guilt here, and that's clear, and also that they're not challenging any of the sufficiency of the evidence.
Can I move you to another issue?
Yes.
On the hard 50, I think we have to determine whether there was sufficient evidence for the aggravating factor, because the new statute says, to me anyway, that if there was insufficient evidence of any aggravating factors, then there's no question that the new one applies. And so I think we've been looking at whether there was sufficient evidence. It seems to me you have to argue two different ways. One, that the defendant was aiming right at the defendant, and number two, for the aggravator, you have to show that there was a risk of harm to more than one person. So make that case to me why both instances apply here.
How they fit together?
Yeah.
Well, I think for premeditation and for the aiming part, that doesn't take away the fact that there was a risk there that someone else could be hit. Because he aimed in their direction still supports premeditation with supporting that risk, because he could have missed. So his aim, I don't think, is I'm losing the right word, but his aim is not
Dispositive.
thank you, Your Honor, dispositive of the that issue here. So I think that even though we argue that aim is very important for premeditation, it doesn't take away that there was a fact of risk of death to more than one person here, and especially considering where the bullets went. Also, I think they can live together harmoniously.
You can aim and still have bad aim.
Correct. And it doesn't take away the risk. And being shot in front of, shooting people in that small of a place doesn't take away the risk.
You can
For that factor.
premeditate the shooting and be a bad shot.
Yes. I think that's what I'm trying to say, Your Honor. Thank you. Also, going back to the harmlessness for the instructional error, I did want to point out that he was not prevented from making his defense, which was, I'm not the shooter, I wasn't there, I didn't do it kind of defense, and also that there was this conspiracy, that all of these witnesses had come up with this story and were very consistent about the conspiracy. So I think that can go to harmlessness as well, is that he was able to present that defense and cross-examined thoroughly all of the witnesses, pointed out all of the inconsistencies in their testimony and the hesitancy to work with law enforcement, and that can go to the harmless error analysis for the instruction issue. And if there are no further questions, I'm finished with my presentation.
Going back to the standard that the judge mentioned for giving a lesser included instruction, just so I understand your position, you're saying the judge did not articulate it properly, but functionally it resulted in application of the right test?
Yes, Your Honor. I think although she used the word could, her agreeance with the state in their interpretation of that evidence functionally she determined that those crimes were not supported by that evidence, and that the only crime that was factually supported was the premeditated intentional murder. And being as that it's so brief, I don't know that there's much else to argue other than the court's agreeance with the state's view on that evidence.
And there was not any kind of objection to her conclusion with defense counsel. At that point, then he just requested the two second degrees.
I believe that's correct, and in my view, he just threw it out there, kind of. He said, well, I feel like I'm obligated to make this request based on that, and the court said, no, there could have been evidence, and agreed with the state's interpretation of that evidence, and he said, okay.
Does the defense have to do anything more than
No.
request?
No, I don't think so, and I think
preserve it for appeal?
Correct. I mean, and I have no issue that he did make that request, but it wasn't an overwhelming, here's all the evidence that was, supported these second degree, murder instructions.
Do you have any further presentation for us?
No, Your Honors, I just respectfully ask this court to affirm the convictions in this case.
Any more questions? Thank you, counsel.
Thank you, Your Honors.
You reserve 3 minutes.
I first of all just briefly want to address the state's claim that the error on the instruction issue was harmless because Mr. Killings was able to present evidence on his conspiracy and he wasn't the shooter theory. We 100% agree that that was his primary defense, but there was also indication that secondary defense was the lesser included.
And that's it was because he asked for them, right?
He asked for it, and if you look at the cross-examinations, and I have it specifically cited in my brief as to when, there was some of the cross-examination by Mr. Rourke that would indicate that he was trying to at least establish some evidence on a lesser included. And I have the specific sites in my brief. I do not remember them off the top of my head. So our argument is he was able to present the evidence on the primary defense, and he did present evidence to support the lesser included throughout the cross-examination. But if a jury isn't instructed that a defense is a defense, does it really matter that they're able to present that evidence if the jury isn't told that legally you can find this? It doesn't. He can, I guess, in comparison, someone can present evidence of self-defense all day long, but if the judge doesn't instruct the jury on self-defense, then the jury can't find the defendant acted in self-defense. So even if he is allowed to present that evidence, if the jury isn't instructed on that law, we would still argue that that's impairs his ability to present his defense to the jury. And the second thing I just wanted to touch on briefly is the prosecutorial misconduct that Justice Biles brought up in relation to that first statement. I first want to point out that this is practically one of the first things that the prosecutor said. He thanked the jury for their service. He commented that they did a great job keeping notes. And then he said, the evidence is overwhelming. The evidence is overwhelming that the defendant murdered Mr. Jackson on January 1st, 2010. So why are we here with this kind of evidence, this kind of physical evidence and testimonial evidence? Why are we here? We are here because the defendant was given the opportunity. He failed to accept responsibility for his homicidal act, and then the rest of it. So
Why doesn't that go to his explanation that he was somewhere else? And that's what that comment it refers to, is he claims he was somewhere else. He failed to take responsibility for what the evidence shows that he did. 5 witnesses, his DNA is found at the scene. All of the incriminating evidence is there. Why isn't that just a comment about that?
I mean, I mean, I guess that's one interpretation of it, but the other interpretation is exactly what Justice Biles
Right, I
said.
understand, but isn't that an interpretation, and in fact, an interpretation which in Finley and Cameron we've accepted?
Yes, but I would argue even in the prejudice section, the harmless error section, I made the argument that all of the prejudicial misconduct is what made it not harmless. So it was not just this isolated thing, it was the repeated comments on credibility, and then to a lesser degree, and I will fully admit that the comments relating to the state presented all of the evidence is on the line, but we would argue that everything, the totality of the closing argument, which started right after thanking the jury, all the way through the majority of his rebuttal, this misconduct that occurred throughout all of it is what shows the ill will, the gross and flagrant, and that, and as we argued, since the majority of the misconduct claim was about the credibility, and this was all about the credibility of the witnesses, it can't be said to be harmless. And just real quickly, this court did find in 2004, 6 years before this case was tried in Tosh, that commenting on a defendant's exercise of his right to a jury trial improperly injected a matter outside the evidence into deliberations, which then also goes into why it was improper. It's not just that he's commenting, as Justice Biles said, the only reason that you're here is because he didn't plead, he didn't accept responsibility. It's that it's essentially asking the jury to consider something other than the evidence presented. And we would argue that the totality of everything, including the long-standing, for 6 years prior to this trial, law, shows that the prosecutorial misconduct in this case was not harmless error. And if there are no further questions, we once again ask that this court reverse Mr. Killing's conviction.
Any more questions? Thank you, counsel.
Thank you.
We thank both counsel for your arguments this morning. The court will take this matter under advisement.